Good morning, Cheryl. Thanks for agreeing to this interview.
Good morning to you as well.
So Cheryl, you're the executive director and senior staff attorney at the Massachusetts Association of Health Boards. And, to just begin this interview, I wanted to start with some background questions.
Sure.
Could you describe your background in public health and tobacco control?
Certainly. I started in 1994, actually. I'm an attorney. I started by representing my own town. The health department was looking at enacting a bylaw that would prohibit smoking in workplaces. And I actually took them on as a client to draft the bylaw and presented to town meeting. In Massachusetts, we have 351 local boards of health, all of whom have the authority to pass local laws, as well as in towns, we have town meetings that also have that authority as the legislative body of the municipality. In cities, it would be the city council. So my municipality took a unique approach in that they were doing this as a bylaw instead of as a board of health regulation. So that's where I started. I was there for a couple of years. Then I went to the Department of Public Health and I became what at the time was called a regional field director. And I managed about 60 tobacco control contracts, most of them being health department contracts that were designed to create policies surrounding secondhand smoke and tobacco sales. I left the Department of Public Health when I was recruited by the Mass Association of Health Boards, which is where I am now, in the year 2000. And I did most of my work was surrounding tobacco control policy. But a few years ago, probably about 5 years ago, it started branching out into other areas of public health law with an emphasis still on tobacco control. And I became the executive director about 3 years ago and the senior staff attorney. So I've been involved quite a while with tobacco control.
Wonderful. Cheryl, so what are your current responsibilities in your current position right now?
Right now, as the executive director, I manage a staff of attorneys and lawyers. There aren't that many. Some are consultants and some are on staff. And I manage them, and I also manage the policy work that we do. We did a lot of work during the pandemic on isolation, quarantine, enforcement. We've written many, many guidelines for that. We are now doing a lot of work on cross-jurisdictional sharing between health departments in Massachusetts, because as I said, we have 351 of them, and they all have the ability to pass local laws, which is terrific. But when it comes to actually delivering public health services, that's where the 351 are really not able to equitably deliver public health services. It depends on their budgets, on the priorities in the municipality, and lots of other issues. And right now in tobacco control, we are dealing with a very challenging situation that California is dealing with now too, with a new product called Newport non-menthol, but which is indeed a menthol product. So right now we're in the process of actually enforcing on that product, and we anticipate that we will not be enforcing without some pushback from the industry. So that's our most recent issue with tobacco control. We passed a very broad statewide law that prohibits all flavored tobacco products with a very tiny exemption. They can be sold and used in smoking bars, which are licensed by our Department of Revenue. We have about 24 in the entire state, and they can only use the products for on-site consumption. So they can't take the products out of the stores, out of these bars. So we've been very busy enforcing that over the past several years. because the fines are extremely high in Massachusetts now. Our fines, a first offense is $1,000 pursuant to state law, second 2,000, and third 5,000. So we have been getting pushback on that, but we are continuing to move ahead and enforce at that level.
So Cheryl, so this is all wonderful. So I'm going to get into a little bit more detail on your work with respect to flavored tobacco products.
Sure.
Well, a little bit more, background in terms of your current job. So what are some of the, what are the most rewarding aspects of your job, would you say right now? And what are some of the challenges?
Well, the most rewarding aspects are, I look at this as a profession, not a job. This is what I do in my professional life. And, it flows over into my personal life as well. I'm a passionate advocate for tobacco control. I think, as one of my friends described years and years ago, I feel good about what I do because I'm on the right side of the issue, in my opinion. And that is very fulfilling in and of itself. I'm fighting, or we collectively are fighting, an industry that creates the only consumer product that, when used as directed, causes death. So I'm passionate about that. And that's what I love most about my job. With the things I don't like about my job, there aren't too many, because every day is really different in the work that I do. I don't like, I guess, although I do like it. I mean, I like the challenge of fighting this industry. I just enjoy that. What I don't like is just meetings that I have to go to that are taking me away from, writing policies and laws. There's really nothing I don't really like about my job, except maybe the paperwork I have to do.
So Cheryl, so let's get back to talking about your work around flavored tobacco products. So could you say a bit more about the history of flavored tobacco products and e-cigarettes in Massachusetts? So how prevalent are they? Who typically uses them?
They aren't as prevalent as they used to be since the law was passed on vaping products back in 2019. They were very, very prevalent, and we were finding them everywhere. When e-cigarettes, Juul was everywhere. We've got pictures of parks where there were just packages and packages of Juul pods, that were just strewn everywhere. And they were especially obviously geared toward kids, and kids were using them. And we saw what happened, and what was just so sad is that we were seeing the exact same playbook with e-cigarettes, with flavored e-cigarettes, as we saw with combustible cigarettes years later, where they were coming into schools and they were talking to staff about how they had this great curricula, and if anyone was using these products, they weren't geared toward kids, and they would give them money to actually use this curricula. And when you looked at it, it was exactly the same as the curricula that the combustible product companies used years and years ago. It's an adult choice, all about choice. But we weren't fooled by that. We'd been through it before. We knew what they were up to. We had sort of an interesting, a lot of things sort of came together around vaping products in Massachusetts several years ago, because our Attorney General actually, was a real proponent of tobacco control, and sued the industry several different times for consumer protection violations. Her name was Martha Coakley. And when she lost her bid, she ran for Senate, I believe. I don't remember what office she ran for, and she lost. And she went to work for Juul. And it really, it was outrageous, and it's still outrageous. And that, coupled with the EVALI injuries that were happening, really helped fuel this outrage in Massachusetts surrounding vaping products. And our legislature, and especially flavored vaping products, and at the time when all of this was happening, like in the 2016, 17, 18, we were passing local regulations around the state that were prohibiting flavored tobacco products, but we were exempting menthol, mint, and wintergreen because we were relying on a case that was decided by the First Circuit Court of Appeals in Providence, and that regulation was upheld by the Second Circuit on appeal. The industry never appealed it to the Supreme Court, so to the US Supreme Court. So we were taking that language because it had survived a legal challenge, and we were promoting that amongst our municipalities because we didn't want them to get sued. We didn't have the resources to really defend them, and we didn't want to be the test case on menthol at that time. So we were going ahead and we were passing regulations that exempted menthol, mint, and wintergreen. And then we reached a point where, in looking at the legal arguments for including menthol, we started to think that we were doing a disservice, not just to kids, but to other populations that were being targeted by the industry when we were looking at menthol. And we changed course, and we started adding menthol to the policies, and we were willing to defend them if they got sued. And sure enough, the handful of towns that added menthol did get sued by a large local law firm. And we put together a legal defense team with help from the Public Health Advocacy Institute, which is in Northeastern Law School. And we got all of the municipal attorneys together, and we were in the process of defending these suits, and we were winning every single motion for a preliminary injunction. Each court was saying this is a reasonable health regulation, menthol's a flavor. We were winning everything. And at that time, the legislature, on almost its own accord, we did have youth come and meet with the legislators, and we of course met with them as well, but they took it one step further and just banned all flavored tobacco products in all stores. We were just looking at adult only retail tobacco stores. We were thinking that maybe they could sell them there, but the legislature said no, they're not selling them anywhere. And the industry tried to lobby, but they had no credibility left. They just had no credibility in Massachusetts at all. One of my colleagues who is a lobbyist was sitting next to someone from the industry, and they didn't know that she was a lobbyist during one of the hearings. And he just looked over her and he said, "This is just not going well for us." And it wasn't, and it was passed almost unanimously. So that's the history behind. I don't know if you want to get into more specifics on a specific municipality, but I'm happy to answer any questions along those lines as well.
Yeah, and I think, Cheryl, this probably ties into my next question, which is, do you think flavored tobacco products and e-cigarettes are a health equity issue in Massachusetts?
Absolutely. They're absolutely a health equity issue. And it's so clear when you look at where retailers are located. We were just talking about this the other day in one of our municipalities, two of our municipalities actually. We were looking at two big cities, one is Worcester and one is Springfield, and we were identifying where the retailers were and where the smoking bars were or are. And they are in environmental justice areas, the vast majority of them. And there's a reason for that. And we know what the reason is. And then if we look at, and we've got a great epidemiology department at our Department of Public Health, and they've actually looked at this, and they've looked at the price of Newports. And the price in these EJ areas of a Newport, of a pack of Newports, is less expensive than it is on Beacon Hill, which is where our state house is. So there's no question. If you just look at the data, you'll see that it's an issue. It's an EJ issue, and that's one of the reasons why we re-looked at what we were doing with menthol, because we were looking at it as, well, if they're only in adult-only retail tobacco stores, then we've got them away from kids. We were completely ignoring the other populations that have been targeted. We were ignoring women, we were ignoring people of color, we were ignoring the LGBTQ community. We were just ignoring, and my bad. I mean, we all did it until we really thought about it. And that was one of the reasons that we changed our approach as well, because we were not getting at all of the targets of the industry. We were just encouraging the inequity.
Thanks, Cheryl. So what local, and I think you already have touched a little bit on this, what local policies did Massachusetts consider, local communities in Massachusetts consider to reduce the prevalence of flavored tobacco products?
To prohibit it. Our policy was to go to the boards of health and to encourage them to enact regulations that prohibited the sale of flavored products. And we did that by really exposing the targeting and the data on who was actually using these products. And that was a successful strategy. You don't see adult males smoking a bubblegum cigar. We didn't see it. We couldn't demonstrate. There are exceptions to every rule, but we couldn't demonstrate that was actually what was happening with the industry. And we went back and looked at some really old data of the targeting, of flavored products, really old. We just took it all out again, because it all existed when the federal government prohibited flavored cigarettes. So we could go right back to that data and then add the data that what kids were using were flavored cigars now that weren't real cigars. They were mimicking cigarettes. It's just they were called cigars so that they weren't covered by the federal law. So, we brought all of that back and were able to successfully make our case. And that's what we do in Massachusetts. We work locally until we get to a tipping point. Where the legislature feels comfortable in enacting a statewide ban. But in this case, it was a little different because they actually were ahead of us, because they weren't exempting adult-only retail tobacco stores. They were including everything. Yeah. So now our retail tobacco stores really don't have a successful business model, because the only thing that makes them different than a convenience store is that they can sell a higher strength liquid nicotine product for vaping. That's it. They can't sell flavored anything. So their business model is a little boring right now.
So what kind of opposition did communities encounter with these policies? So starting from the beginning, and I think you already mentioned some. So there was the Providence Island case.
Providence, Rhode Island. Yep.
Right. So was there any other kind of opposition from the industry to some of these local efforts?
Oh yeah. There was the strategy that the industry used with the lawsuits. That was an attempt to thwart any more activity. But because we kept winning the lawsuits, winning, they never went to trial. Because we kept winning, that argument wasn't really working. And in fact, the fact that they sued was one of the reasons that the state passed a statewide bill. Because here's the industry suing all of these cities and towns, not all, there was probably about a dozen. So they're suing all of these cities and towns, which are costing, which is costing municipalities money. And then they're trying to lobby the legislature to not pass this. And that's one of the reasons they didn't have any credibility. The other challenge that we really had was not so much in getting the laws passed, because it was very easy to explain that menthol's a flavor. I mean, you have to be from a different planet to think it's not. But what we were getting pushback on a lot was the fact that we were enforcing on products that not only were called flavored, like cherry black and mild, we were also enforcing on products that we knew were flavored, because when you opened them up and you smelled them, they didn't smell like tobacco. And that's the definition of a characterizing flavor, something with a taste or smell other than tobacco. So we were enforcing on all of these, and I just call them implicit flavored products, not just explicit, but implicit. And that was new in the world of tobacco control. Not many, but there were some jurisdictions that had flavor bans, but were not enforcing on products that were flavored but weren't called flavored. And Jazz is a perfect example of a product that's called Jazz, a black and mild. You opened it up and you could smell it from across the room, and it didn't smell like tobacco. You can't smell a Marlboro that's not lit from across the room. You can't. Jazz, you could. So we enforced on those, and of course we got sued for enforcing on this product, because Cumberland Farms is one of our, it's a chain. It's mainly in Massachusetts. It's also in Florida. And they are a unique sort of industry of business, because they're not franchises. They're all owned by Cumberland Farms. So everyone who manages them are employees of Cumberland Farms. So it was a different model than we were used to. There were no they would buy directly from the manufacturers. And they sued one of our towns. They sued Yarmouth, which is on Cape Cod, claiming that Jazz wasn't a flavored product. And so we ended up in court on this with this product. We went to court, and this could take me forever to describe.
Well, Cheryl, this is actually that was going to be my next question.
Oh, okay. This is one of my favorite. This is why I do this work, because of challenges and fights with the industry like this one. Because in my opinion, and I feel this way about the Newport non-menthol as well, if we let this go and we didn't enforce on Jazz, when everyone who smelled it knew it was a flavored product, then we might as well pick up our toys and go home, because this is where the industry was going. We knew this was where they were going, and they weren't going to stop. So they sued us in Superior Court, which in Massachusetts is a pretty high court. It's not a district. You have district and superior. So you don't mind me talking about this?
Well, Cheryl, yeah. So I was going to ask about Yarmouth, because I completely agree with you. That's a very significant case, with respect to these concept flavors. So what was the Yarmouth policy specifically? So first of all, give us an overview of the policy itself, and the litigation that followed, and then talk about the smell test as well. How that.
Yeah. Okay. Great. So the Yarmouth was actually the first municipality to actually enact a flavor ban in Massachusetts. It was one of the first ones. I think it was in 2014 or something. It was early on, and it wasn't a perfect case. We have a tobacco control director for Yarmouth. He's wonderful, Bob Collette, but he wasn't the one that issued the ticket on Jazz. It was a health inspector in the town found Jazz. And at the time, we were also in the process of trying naively to create a list of all of the flavored products, both the explicit and the implicit. We were trying to do that because we thought it would be helpful to the field. So I had one of our policy analysts at MAHB try to put that kind of list together. In hindsight, that was not a smart thing to do, because what happened was we couldn't keep up with the products that were being developed and put on the market by the industry. You know, we were playing like we always play with this industry. We were playing whack-a-mole. I don't know if you're familiar with that game, but you know, you hit one mole and then another one pops up, and that's what we were doing with the industry. We were playing whack-a-mole because they kept creating new products, and then, you know, we allowed them to appeal, and you know, and we were doing the sniff test, but we didn't really know what the sniff test really should look like, because this was all new, and we were the only ones that were enforcing on these. So we ticketed. The Cumberland Farms came before the Board of Health for a hearing, and at that hearing, they claimed that the product was not flavored, that they had spoken with someone from Philip Morris, who indicated, because Black and Mild is part of Philip Morris, Altria owns Black and Mild. So they insisted it wasn't flavored, and they went through the differences between natural tobacco. Like you've got Virginia, you've got Bright Leaf, you've got Maryland, you've got Oriental, and they basically were saying, we didn't know what we were talking about. This is just a natural product that was grown and cured in a place where the product smells a little sweet, but that it wasn't a flavored product. The Board of Health didn't believe them, and they upheld the fine. And that's when they sued the Board of Health. And we went to court, and I'm thinking, and my colleagues are thinking, you know, we've smelled the product. Why don't we just let the Board of Health smell the product as well, so they can get a sense of what this product is? But we didn't do that before the hearing that the Board of Health had. So we had smelled the product, the board had not smelled the product. And they took our word for the fact that we smelled it and that it was flavored. So we go for a hearing for a preliminary injunction, which would mean that the Cumberland Farms could keep selling the product. That's what they wanted to do until the trial was held. The judge asked Cumberland Farms to stop selling the product until the case was resolved. So they agreed to that. And he remanded the case, or he sent it back to the Board of Health to hold another hearing. So at that hearing, and you know, we were all there, and they were very intimidating. You know, they brought a court reporter, which you don't do at an administrative hearing, but they did all of this stuff to make them look so serious and so important. So we, at that time, and I was there, and the board was listening to the evidence, and again, we're not in a court of law, we're at a hearing before the Board of Health. So I suggested, why don't we just open this up, and board members, do you want to just smell it? So they objected, they jumped up and down. No, we don't want to do that. You know, you don't need to do that. That's not what we usually do. So the board said, sure, open up the pack and give it to us and we'll smell it. You know, they're sitting around. So one of the board members was a very elderly gentleman, and he recused himself because he said he didn't have any sense of smell. The other four smelled it and immediately said, this is flavor. So, and upheld the fine. So we went back to court because they appealed. They used what's called a writ of certiorari. They went back to court saying that the Board of Health had done something wrong in the way they addressed this. And their evidence was, it wasn't scientific, it wasn't this, it wasn't that. And the town attorney was wonderful because we met. He had been great. He had been really great in defending them. And we helped him immeasurably because we had all the research. And we had testified at the hearing before the Board of Health. So we're in this little room in the courthouse before the hearing on the writ, is what it's called. And he says, I said, listen, Mike, do you want to smell this? And he said, yeah. So he smelled it and he said, oh my God, I was so afraid I wasn't going to be able to tell whether it was flavored. He said, this is unbelievable. This reeks of like this cloying. It didn't smell like tobacco, basically. So the argument was held, and then the court ruled and wrote a decision that, you know, all you have to demonstrate is that it smells like something other than tobacco. You know, and that was the ruling that we were hoping for, because that is all the law says, is that it has to smell or taste like something other than tobacco. So that's my story on that case. And no, they didn't appeal it. And it has been relied on by many folks, because it's just, you know, boards of health and public health inspectors use smell all the time when they're enforcing. They smell for mold, they smell for rotten milk, they smell for dumpsters that aren't big enough in multi-unit dwellings. They use their nose all the time as a means of enforcing on public health issues. You know, I could go on, camps with, you know, swimming devices that are moldy. There are just so many ways we use our smell as a way to enforce. And saying that smelling a tobacco product that's flavored is in a different category than any other enforcement, any other product that we'd be enforcing on, is ridiculous. And that's basically what the court said, that you don't need to be a scientist to know whether a product smells.
Yeah.
You need a nose.
Yeah. So Cheryl, is the smell test the primary test used for enforcing flavors in Massachusetts right now?
Yeah, that is what we're using right now. I will talk a little bit more about the taste, because with menthol products, it's not so much the smell, it's the taste. It's the sensation you get when you inhale that product. Anyone who smoked a menthol cigarette, and I have numerous times in my past life, you know, you don't taste tobacco, you taste the menthol. That's why you smoke it, because you don't taste the tobacco. But let's stick with the smell test, because that works for every other product except for the menthol. Works for every other product. And what we ended up doing, and it was quite controversial at the time, but we didn't think it was, because we had a decision from a Superior Court judge that was not appealed that the smell test was appropriate. Actually, wait a minute. It was appealed. It was appealed to a single justice, and that justice ruled the same way, that the smell test was fine. It wasn't further appealed. So we had a decision that said the smell, all you need to do is smell. And we wanted to figure out, is there some sort of a protocol that we should be following when we're trying to determine whether a product smells? And this was without the permission of DPH. We did this on our own. It was me from the Mass Association of Health Board, my colleague from the Mass Health Officers Association, my colleague from the Mass Municipal Association, and my colleague from the Public Health Advocacy Institute. So the four of us put together an experiment, basically, with our field, with the tobacco control directors from across the state. And we asked them to, and we did it in an independent location, and we asked them to bring products that they felt were flavored, but that weren't explicitly labeled as, that didn't say they were flavored, but the ones that were implicitly in their mind flavored. And we went to this location, and we provided the control, basically, the conventional unflavored product, like we used Marlboro. And we set up a pretty intricate experiment where we asked them to come And we did it. And again, this is just what we did. You don't need to be this, what's the word I'm looking for? You don't need to be this sort of controlled when you're actually smelling something. But we took, like, could this be a best practice? Maybe, so we tried to think of what would it look like. So we had fresh tobacco, and they were told to bring fresh flavors. So it was like, it couldn't be more than 3 days old. And we had them go into a room where there was no food, no drink. The only thing that could be in there was water. They couldn't talk to each other. Our field likes to talk a lot. So they were in round tables, and we said no talking. And we presented them, and I did a lot of research on natural tobacco. So before we started the sniff test, I went through and had them smell real tobacco, right from natural tobacco that came from different places. So I walked them through how you grow tobacco, how you cure tobacco, how you can put chemicals into it, like you could put flavors into it to make it smoke more mildly, but it's not going to change. You're still going to smell tobacco. And I had them actually smell these big things of tobacco, and they smelled they all smelled like tobacco. They smelled a little different, and we kept them outside to keep them away because they really did smell. So we did that piece first, and then we had them in the room, and we had these little cups, and some of us were in the back of the room, some of us were helping them with smelling the products, and we had them smell the conventional tobacco, the unflavored tobacco first, and then we had them smell one of the samples of the flavored tobacco. And we had a worksheet that we had put together. And again, no talking. We put this worksheet together, and the worksheet started out with, what are characterizing flavors that are used in tobacco? And then, like, there's sweet, there's bitter, there's umami, there are all these, like, there are 6 of them, I think. I don't have it in front of me. I can send it to you, but we had, okay, these are characterizing flavors. These are specific flavors that go along with the characterizing. And then ultimately, does it smell like something other than tobacco? And we had them do it for, I don't know how many products we had. I think we had about 15 to 20 products, different flavored products. And then we collected the results from this test. And what those results, when we went back to our offices, and this was all during the pandemic. It was when you didn't have to wear masks at this point. But so we did a lot of this work because we weren't doing a lot of enforcing during the pandemic, because we weren't going out to convenience stores. Some of our programs just didn't want to. So this was something, the timing was really good for this. So when we brought the sheets back and we looked at what everyone said, we saw some patterns. We saw that most people they agreed pretty much on, like, the major categories, like, is it sweet, is it sour, is it umami? They agreed on some of that. But when it came to trying to figure out what it actually smelled like, people were all over the place. But where they weren't all over the place is if you asked them if it smelled like something other than tobacco, everyone said yes. So, or virtually everyone said yes. So we took that information and we said, you know what? We don't need to go through these 3 steps. We just need 1 step. Does it smell like something other than tobacco? If it does, it has a characterizing flavor. And that's what we've been using ever since. It was good to do the exercise because it was helpful to realize that we're not held to that standard to determine what it smells like. We just have to determine whether it smells like something other than tobacco. And everyone felt really comfortable with that conclusion and with that finding. So that's what we're using. Now, I don't know if you want to ask questions, or do you want me just to go into the challenge now with the Newport? I don't know.
Yeah, but I guess I had a question. It's somewhat of a side question. Is so I mean, so is that the protocol? Do you typically, so when you're testing, for a product that that could be flavored, do you just have one person smell the product, or do you have a panel, a number of people, or just?
It depends on what the Board of Health wants. We leave that decision to the local Board of Health that's actually enforcing the law. Some boards want to smell it themselves. Some want the tobacco control director to do the smelling. Some want their inspectors to do the smelling. So it really depends on what the Board of Health wants. That's where, we leave decisions like that to the local enforcing authority.
Okay. Okay, so let's talk about this new challenge, this new product, Newport, and what some of the issues you're currently having to deal with that.
Sure. It arrived in California before it arrived in Massachusetts, but now it's here in Massachusetts, and we're hearing conflicting stories, and it's all anecdotal right now. When we look at the advertising of the product, it is clear that it's being marketed to menthol smokers. There's no question in anyone's mind that that's who it's being marketed to. And the packaging, everything about it just screams an unfair and deceptive business practice. Everything screams that. It's a violation of the consumer protection law in Massachusetts. There's no question about that. Without even smelling or tasting the product. It's just a violation because of the way it's being targeted. Now, having said that, we actually, and this was quite controversial as well, but from my experience, it's really hard to detect a smell on a menthol product. So that means you'd actually have to have some evidence that it tastes like a menthol product, that it smokes like a menthol product. So what we initially did, because this is, we're like bulls in a china shop, we said, let's see if we can find some folks that smoke menthol and see if they want to try this product and see whether they think it's smoking like a menthol product. So that's what we did. But I should first say, and this is really interesting, that the retailers in Massachusetts, once this product came to their stores through their distributor, they came to the health departments and said, can I really sell this? I mean, this looks to me like it's a menthol cigarette. I haven't tried it, but this looks like a menthol cigarette. So that's the first thing that happened, which is really interesting, that they thought there was something fishy about this product. So that's the first thing that happened. Then the second thing that happened was that we asked some folks that we knew if they knew any menthol smokers, and if they did, could they have the menthol smoker smoke this and see what they think. And we found two things. Again, this was anecdotal. There's no science involved in this whatsoever. But everyone, with the exception of one person, and there were probably, again, about a dozen that smoked this, said it was menthol. The other person just said it was awful, that, it was awful. Well, they didn't know what it tasted like, but it was awful. So we said, okay. And we did a little bit of research, and we know what the chemical is, W3 or whatever it is. It mimics menthol. So in our opinion, since it was mimicking menthol, and since the folks that were trying it said, yeah, I feel that sensation, we said, this is a flavored product. I mean, how much further do we need to go? And some folks were really concerned that we were asking someone to smoke the only consumer product that, when used as directed, causes death. But when I look at public health law, holistically, we're constantly doing a balancing test. Constantly, every time we're enforcing on something or creating a policy, individual rights versus public health, business rights versus public health, privacy rights. And I felt that when I did the balancing test of asking a smoker to try this product versus the larger good of trying to keep these products away because they're flavored, I felt okay with that decision. And so did most of my colleagues felt okay with that decision. So when and then the other thing we found, and I just got an email this morning from another one of our field folks, that some menthol smokers don't like this product. It's menthol, but they don't think it's any good. So it might, die its own death if it's not a good product, but I doubt that's going to happen, because if this product isn't any good, they're going to just create another one that is a better menthol taste than this menthol taste. So what we are going to do, and when these first came, I was concerned and wanted to speak with other public health lawyers around the country that specialize in tobacco control. So I contacted your shop and the Campaign for Tobacco-Free Kids, and we had a Zoom call a couple of weeks ago on this product. And we told them what our intentions were, that in our opinion, this was a flavored tobacco product because it tastes like something other than tobacco. And that's what we're going to enforce on in Massachusetts. We're going to enforce on this. I was a little concerned, and I still am concerned, and I'm not the only one in Massachusetts who is concerned, that the knee-jerk reaction, and it's an understandable reaction, but the knee-jerk reaction is to tweak your law so you cover it has a sensation, a coolness. You don't have to do that. That's playing into the industry's tactic. That's playing whack-a-mole with them again. Oh, we don't like what they did, so we'll change our law so that it covers that. We already have a law that covers this. We don't need to change the law because they're trying to find a loophole that doesn't exist. So we're a little concerned that knee-jerk reaction is going to get in the way of our trying to enforce on the law the way it's written. But we're hoping that doesn't become a real issue, because we think the law is crystal clear. If it tastes like something other than tobacco, it's flavored. And without defending that, I don't know why you would change a law without defending this first. And if we lose, although I don't know how we'll lose, but if we lose, then you think maybe I need to change the law, but not before you fight on it. At least that's our position in Massachusetts. We're not doing anything because we are certain that this is a flavored product.
Sure, so you had mentioned earlier, because this, a question that sort of arose in my mind when you're talking about some of the balancing tests you have to do in terms of having like smokers, menthol smokers try these products. You had mentioned earlier that the test for other flavored products, as the smell test, can't generally be applied to menthol flavored products. So how have you guys historically enforced or tested for menthol?
We have not tested for menthol because the menthol was all taken off the shelves. Okay. And everyone has acknowledged that menthol is a flavor. The FDA acknowledges that it's a flavor. They say it's a flavor. The industry and some of their ads say it's a taste. So that product was never challenged. Okay. So the only reason this is being challenged is because it says right on the label, non-menthol. Mm-hmm. So menthol was easy. And now all of a sudden they're trying to say it's not easy anymore. It's ridiculous. It's ridiculous.
Yeah. Yeah. So Massachusetts is one of the first states that passed a fairly comprehensive ban on the sale of menthol and other flavored products. Why do you think the state did this?
I think they did it because of Number one, the EVALI diseases. The governor banned the sale of all e-cigarettes once he found out about that through physicians at Mass General. When he found out what was happening with that, he banned them. So I think that was one thing. I think the lawsuits against municipalities by the industry was the second thing. And I think we have two incredible champions, but this was really Senator Keenan. Back when we passed the law that increased the age to 21, the state law, he wanted to ban flavored products then. And in that legislative session. And it didn't happen. So in the past legislative session, when this law got passed, he's the one that filed it again. And the youth in his municipalities were the ones that came to him about these products, and he was furious with these products. So we had two champions that were incredibly impactful with the state and the Senate, and I with the House and the Senate. And I just think I think that was the confluence that because it happened really quickly. It was the desire of Senator Keenan, because of the youth that he had been speaking with, the banning of e-cigarettes by the governor through an emergency order, and the lawsuits that were brought by the industry. I think you put it all together. And we also have some just excellent advocates at the State House. American Heart, American Cancer, Lung. I mean, these guys were just incredible when it came time to really push this. And they have a lot of credibility in our state. And it went really quickly.
So was there any opposition to
No.
the law? None. Okay.
No, just the lobbyists.
Okay.
And they had no credibility. So, you know, and I don't think it was unanimous. I could look back and see, but it was virtually unanimous.
Okay. That's incredible.
Yeah.
Yeah. So how effective has this state law been in stemming the sale of menthol and other flavored tobacco products, including e-cigarettes?
That's a good question. And I can't give you a really good answer because our EPIs are looking at that right now to see what the data actually says. It does indicate, and I'm just from memory thinking about what a discussion we had with the EPIs, everything, the sale is going down. Initially, there was a move to go to New Hampshire, to a bordering state. And there was a lot of activity around the borders of folks of New Hampshire stores trying to capture, but that always happens with any product. That happens because they have lower prices, they don't have sales tax. You know, there are lots of reasons why that happens. That's calmed down considerably. And one of the talks that our EPIs gave actually at the last tobacco control conference went through and talk about systemic racism. It looked like the white population was going up to New Hampshire to buy products when the law first went into effect. And those urban smokers, people of color, were getting them illegally off the street, which is much more dangerous than going up to New Hampshire. And you can figure out, you know, lack of transportation, lack of resources, you know, all of these things were coming into play here. We can't deny, well, so what some of the studies that I've seen are saying is that the smoking rate has gone down amongst menthol smokers with the exception of Black women. That rate is not going down as quickly in Massachusetts as it is in other states. So I don't know what that means. What it's been attributed to is the pandemic and the stress on Black women. Might be one of the causes for it not going down as quickly. But that's what we're
referring
saying.
to the ACS CAN study?
Yes.
Yes.
Yes. And our reppies are looking at specific Massachusetts. One thing that we really want to find out, and we haven't been able to because we've only had anecdotal information, is what's happening with youth. We haven't been able to survey them because of the pandemic, and we are now in the process of surveying them. So that's going to be really interesting data to see what's happened since that went into, since now that they're back in school and we can get that survey data. That's going to be helpful.
Yeah. So Cheryl, what suggestions do you have for states and local communities that, that are considering adopting similar flavor restrictions?
The biggest suggestion would be to do a lot of educating, of parents, of physicians, of boards of health, of community-based organizations. And we have a lot of this. I'm sure they can get it, but I'm happy to give my PowerPoints to anyone who wants them to, just look at what's in them, look at the kind of data that is the most impactful. And you need that education piece. It's one thing that we really didn't have the chance to do as much as we wanted to when it came to the menthol piece, because we, quite frankly, didn't think the bill would go so quickly, would be signed into law so quickly. So we had a lot of education on flavored, but we didn't have a lot on menthol because we had just started. We'd been doing menthol for a couple of years, but we didn't have a lot of time to do the education that we wanted to do surrounding menthol. So I think the education piece is the most important piece to do, especially if you're in a state that just isn't ready to look at this, and that doesn't have the time or the resources to put in that you actually need to put in to this area. And to feel free to contact folks in California, in Minnesota, in Massachusetts, wherever this is going on, feel free to use them, to call them up and ask them what, if you're having a specific issue with a specific agency or population, call and pick our brains about what worked. And sometimes, you're going to feel like you're hitting your head against the wall. That's how we felt. But if you're determined, then, it's going to get through. I mean, these adults don't use these products except menthol, and menthol is targeted, and it's an issue of racism. It's an issue of health equity. And when people realize that, when they actually see what's happening in the cynical nature of menthol and how it makes it easier to smoke and it attracts kids because it's smoother. I mean, that's why I smoked menthol, because it was easier to smoke. So, that's the advice, is to do a lot of educating on what these products are and what the industry tactics are, looking at those documents and seeing, when they say, there was one that was particularly compelling, I don't smoke that stuff. I save it for the stupid, the black, and the uneducated. I wouldn't smoke that stuff, from a Philip Morris executive. That's compelling, that they are creating products that kill people, and especially products that are flavored. Yeah. I think it's compelling.
It is compelling.
And then when you also, I think educating folks about what a flavored product is also important, to know the different strains of tobacco and how that argument, don't go down that rabbit hole that you need to prove what chemicals are in the product, because you don't. And that's really important, because if you end up with this sensory panel, you're going to be tripped up forever, because you're never going to be able to afford that for all products, and you don't have to.
That was actually my next question. And so one part of it is just getting the policy through, and how do you actually, pass, build the political support for the policy. And the other part of it is, once you have the policy in place, how do you make sure that it is appropriately enforced?
Yeah.
And so what would be your recommendation for communities? I'm thinking about, states or localities that have, I think California might be I think it's the only state right now that has, a comprehensive policy similar to Massachusetts, and localities that may be facing enforcement challenges particularly with respect to those implicit flavors, like concept flavors. What would be your recommendation?
My recommendation would be to make sure that the law you pass has that language in it, has the definition of characterizing flavor is something that smells or tastes like something other than tobacco. That's the language that needs to be in the law. And then you keep it simple. You just keep it simple. If you suspect a product is flavored because you've heard that it's flavored, what we do first is, before we do the smell test, we do some Google searches. See how it's marketed. See if there are any YouTube videos. Usually you can find these 14, 15-year-old boys in front of their high school doing a review on a flavored little cigar, because it's cool, like, to them. So we did a lot of, that's what we do first, before smelling anything, is just see what we can find. The marketing is the big thing. And what was interesting is and we had that evidence in the Yarmouth case. We had evidence of jazz being described as a flavor. What the industry has done since, their claim was that, well, that's marketing from third parties that sell our product. We're not marketing it as a flavored product. They are. So you can't blame us for it. Well, they're marketing it as a flavored product because that's what it is. And that that's what they're doing. So it was a disingenuous argument from the beginning. I spoke with one of the Philip Morris attorneys when this first happened, when we first fined on jazz. And he said, oh, it's not flavored. I said, have you smelled it? No, I haven't smelled it. Cumberland Farms attorneys wouldn't smell it. So, and when you look at the marketing, the board was just furious when they saw how this product was marketed. It was marketed as flavored. And so that's what we do first. Okay. And sometimes that's all. Sometimes our programs will just go into the retailer and say, look, this is how they're marketing it. And they'll say, you're right, it's flavored. Sometimes they'll want to smell it, and we'll open it up. And that's when we do the smell test. If they don't, if they don't think that the marketing is enough, then, we'll buy a pack and open it up and smell it. And our programs have brought the product in to their retailers and said, you tell me whether this is flavored. And they'll say it's flavored. You're right. It's flavored. Now, we also in Massachusetts require, and again, the legislature did this, we didn't, but they did it based upon what was happening in other countries. We also ban flavor tobacco product enhancers. So one thing that the industry was doing was they were adding these little capsules to products to make them menthol products. Well, that's a tobacco product flavor enhancer. That's not allowed. In Massachusetts, you can't do that. So that's another piece that you would want to put in your law. And then the other piece would be getting a manufacturer's letter from the manufacturer attesting to the fact that the only products, and they have to have one for each product, that this product is not flavored, signed under the pains and perjuries by Philip Morris. So they have to have those, the retailers have to have those letters for every product. And if they don't have a letter for every product, they need to take it off the shelf until they get the letter, because it's written in the law that they have to have this letter.
I think Massachusetts is the only state that has that requirement right now for,
Yes.
yeah. Yeah,
And it's a double-edged sword, because, it's not, the retailer has to ask the manufacturer for the letter. We got a letter from RJR on this Newport non-menthol saying it's not flavored. So if they've not told the truth in that letter, that's something that our Attorney General's office is going to be looking at as well.
Yeah, that's wonderful. Cheryl, do you have any closing thoughts or comments?
Just to not give up, that this is an industry worth fighting, because they are out to kill us. It's really that simple. And they're out to kill our kids is what they're really out to do, because that's how they make money. So, just persevere. You're on the right side of an issue that's really important, and your work is valuable, it's important, and it's really imperative.
Thank you, Cheryl. This has been a very informative interview. Thank you for joining me here.
Thank you.